What's going on, people? I wanted to talk about some of these things that'll help you in court. I remember somebody made a comment one time. They wanted me to watch somebody's video, break it down to 12 presumptions of court. I already had the documentation, I already knew it. I didn't want to disrespect the person, but I was like, you really can't break this down more than, if you know federal rules of civil procedure, canon laws. There's no, you can't really break it down more to a point that I won't understand how to use this. So I didn't want to disrespect that person, but sometimes, it is what it is. Um, but you have to understand in the court, you're really battling presumptions. Now, to keep court simple, for most of you guys, some people, I heard a comment one time, a person was basically telling me, "Oh, you're the law overview or your law thing," or not my video, but my YouTube video, but not the video, my 401 video. They were trying to tell me that it was like high school law. And I'm like, really, law is simple. Like, unless you get into a complex situation like injury, um, something like the division of assets, law is pretty simple besides that. You see what I'm saying? Or murder or something like that. Um, or hearsay or whatever. Anyway, law is very simple. Okay. People try to make law complex so the average person doesn't understand it. So you have to understand when you're dealing with court, you're really just dealing with a record. Okay, somebody stated you did something. There are presumptions of law, and most people do not understand that, and they do not address the presumptions of law. That's why I put the video out that I have coming out on the 27th. It is not to diss anybody. It's because people don't deal with presumptions first in regards to court cases. Okay, so the 12 presumptions of court. A Roman court does not operate according to any true rule of law, but by presumptions of the law. Therefore, if presumptions presented by a private bar guild are not rebutted, they become fact and therefore said to stand true or truth in commerce. There are 12 key presumptions asserted by the private bar guilds, which, if unchallenged, stand true, being public record. See, this is what I was telling people for a lot of people who follow me on Instagram, a lot of people who do consultation, whatever. I'm trying to tell you guys, if someone's suing you, the court is operating off the record. They're not operating off of you coming to court, making claims or stating things stating things objectively, not even objectively, but stating things on a record. The court is going. The court is basically saying, okay, this person alleges this. Until we see anything that contradicts it, we're going to say that's correct. Okay. Public service, public oath, immunity, summons, custody, court of guardians, court of trustees, government as executor/beneficiary, executor de son tort. So I know you've seen my video where I was talking about trustees de son tort, how you can basically take the court when the court, basically when the court violates your rights or agents of the court violate your rights, you can basically bring a claim against them and they become trustees de son tort because the court record could be used as evidence, to be used against them in confidence and guilt. Okay, the presumption of public record. It is that any matter brought before a lower Roman court is a matter for the public record, when in fact it is presumed by the members of the private bar guild that the matter is a private bar guild business matter, unless openly rebuked and rejected by stating clearly the matter is to be on the public record. The matter remains a private bar guild matter, completely under private bar guild rules. And now let's just take out private bar guild and let's just say that it's an administrative matter. Okay, it is a general administrative matter. So when you walk into court, you do not understand the rules of court, you generally submit to court. To understand the rules of court, you need to understand banking. You need to actually read your rules of court, but the key is to understand banking. So I know there's going to be people on the video saying, "Oh, you don't know what you're talking about. The court has nothing to do with banking." It has everything to do with banking. Everything. everything. And if you don't believe that, you can believe whatever you want to. I could prove it. It's a fact. There's no presumption. The court operates under the same elements of a bank. If you understand all the rules of federal civil procedure, you'll understand what I'm saying. Okay. The presumption of public service. It is that all the members of the private bar guild who have sworn a solemnly secret oath, absolute oath to their guild, then act as public agents of the government or public officials by making additional oath of public office that openly and deliberately contradict their private superior oaths to their own guild. Unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public service and therefore trustees under public oath. And now, what they're talking about in this manner is they're talking about their ability to transfer property or turn over property, which means, if you're an attorney, that means you're there to attorn property, to turn it over. So if you go to court, or like say if you're sued in a repossession or a eviction or a foreclosure, you'll always see that there's an attorney on the other side. And you're like, what the hell is this person doing here? I'm suing the corporation. Why aren't they sending an agent? It's okay if they have an attorney, but why isn't an agent from the corporation showing up? Because shouldn't they have to defend themselves like I have to defend me? Well, what they're saying is that these agents are acting under the public trust. So they're acting like they're acting in the best interest of the public when they're really not. They're all acting for profiting for private gain, if that makes it clear for you guys. Okay, the presumption of public oath. It is that all members of the private bar guild acting in the capacity of public officials have sworn a solemn public oath, remain bound to that oath, and therefore bound to serve honestly, impartially, and fair as dictated by their oath. Unless openly challenged and demanded, the presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. So basically, what they're trying to say is like the judge, the prosecutor, they carry two roles. So they carry the role of being sworn to the bar, and then they carry the role of being sworn under public law because prosecutors and DAs, they do have to swear to the Constitution, and judges do have to swear to the Constitution. So that's basically what they're saying, which is true. It's true. I'm going to sit there and say it is true. If challenged, such individuals must rescue themselves as having a conflict of interest and cannot possibly stand under a public oath. And number 4, the presumption of immunity. It is that key members of the private bar guild in the capacity of public officials acting as judges, prosecutors, and magistrates who have sworn a solemn public oath in good faith are immune from personal claims of injury and liability. Well, I've already debunked that. I didn't do a video to do that, but somebody got pissed at me. Uh, they got pissed at me because I said judges do not have immunity. Um, that people think. People think that judges have immunity, um, but judges are not immune. They're immune within making their decision, meaning they can make a decision as long as the decision conforms with the Constitution and the state law or the state statutes. Then they're immune from being sued privately. Well, not immune from being sued privately. They can be sued privately, but they're immune from being sued civilly based on that decision, if that makes sense. You see what I'm saying? So it makes sense in all actuality. Like if I'm a judge and I'm actually doing what I'm supposed to, I'm doing my job, and then I'm not ripping nobody off, I'm not stealing nobody's property, but the person was in the wrong, then they come back and sue me civilly or criminally, whatever. But I'm doing my job. I should have immunity within the disposition of my job, if that makes sense. Like a police officer should have immunity when they're doing their job. But when they infringe on people's rights, then they don't have any immunity. Okay, unless openly challenged and their oath demanded, the presumption stands that the members of the private bar guild, as public trustees, acting as judges, prosecutors, and magistrates, are immune from personal accountability for their actions. Okay, so they're not immune from it. It's basically the whole immunity is basically a judge is immune within his decisions as long as his decisions conform with law. But if a judge tries to take over law or tries to make private decisions or decisions that don't conform with the Constitution of law, they're liable for their decisions. So the presumption of a summons. It is that by custom a summons unrebutted stands, and therefore one who attends court is presumed to accept the position, defendant, juror, witness. This is a fact. So when someone serves you, you have to understand that if you allow the summons to take place, then you're going to be dealing with an uphill battle. A lot of times, what people do not do is they do not challenge the summons, they do not challenge anything, and then they get into court. Now they're getting sued. Now they're getting their car repossessed. They're getting their home foreclosed on. Okay, and the jurisdiction of the court. Attendance to court is uh, usually invitation by summons. So this is why when I was talking about the traffic stuff, where I was saying that a summons, I mean a traffic ticket is not a summons, and yet you had these attorneys or whatever these bot accounts sitting here trolling me, trying to tell me that a person has to appear in a traffic course. No, in traffic is they could say traffic is quasi civil, a quasi jurisdiction. Well, I don't have to participate with that. They still have to follow the rules of civil court unless they could say that they could prove that it's a criminal uh, uh, they prove that it's criminal in nature. So then it has to be under the criminal statutes. If it's not under the criminal statutes, which most traffic violations aren't, they add statutes to make them criminal. Okay. Unless the summons is rejected and returned with a copy of the rejection filed prior to choosing to visit or attend, jurisdiction and position as the accused and the existence of guilt stands. Okay, this is why I always tell people when I try to coach people, I try people. You need to tell people that you need to attack the the uh, the court case from its inception. If you don't attack it, if you don't attack any of the orders or anything, they stand. Okay, so then you have to understand how to challenge this stuff. And since people don't understand how to challenge it, they end up becoming a public charge for it. They become liable for it. Okay, the presumption of custody. It is that by custom, a summons or warrant for arrest, unrebutted, stands, and therefore one who attends court is presumed to be a thing and therefore liable to be detained in custody by custodians. This includes the dead legal fiction non human person that corporate governments, rules, and regulations are written for. So yeah, it's basically every when they're talking about persons, they're talking about just legal entities that they created, which is your name, and they use it in a legal entity capacity. And that's where somebody argued with me also. And I said, well, you have to understand what they're talking about a legal person. They're not talking about just natural persons. They're talking about legal persons because they have to. They have to because a person can mean a corporation or an entity. So custodians may only lawfully hold custody of property and things, not flesh and blood souls possessing beings, unless this presumption is openly challenged by rejection of the summons or at a court. The presumption stands. You are a thing and property, and therefore liable. I mean, therefore lawfully able to be kept in custody by custodians. So what they're basically saying is if you do not challenge a, or if you do not basically challenge the elements or the nature of the cause or challenge anything, they're going to presume that everything they're doing is correct. That's basically how court works. So for all you guys who are sitting here like thinking you need to learn every case. No, you need to understand how court works. Once you understand how court works, even if they run over you, you'll know what to do. Okay, the presumption of court of guardians is the presumption that as you may be listed as a resident of a ward of local government area and have listed on your passport the letter P for pauper. You are a pauper and therefore under the guardian power of the government and its agents as a court of guardians, unless the presumption is openly challenged to demonstrate you are both a general guardian and general executor of the matter trust before the court. The presumption stands and you are, by default, a pauper, a lunatic, and therefore must obey the rules of the clerk of guardians, clerk of magistrate court. Okay? So it all boils down to, I understand what the context that they're stating, but it all boils down to challenging the record, challenging the presumptions. Okay, you don't have to say I am not a ward of the court and all this stuff, but you can do that if you feel that that's how you have to address the matter. Okay, the presumption of court of trustee. It is that members of the private bar guild presume you accept the office of trustee as a public servant and government employee just by attending a Roman code such as courts are always for public trustees by the rules of the guild and the Roman system, unless this presumption is openly challenged to state you are merely visiting by visitation, invitation to clear up the matter. And you are not a government employee or public trustee in this instance. The presumption stands and is assumed as one of the most significant reasons to claim jurisdiction just because you appeared. And so, pretty much, if you appear and you don't bring your intentions behind your appearance, the court is going to assume by general default that you are the defendant and you are liable for all the obligations. Now, I can get into this and make it super deep, but I'm not. I'm just trying to get this out to make sure that you guys understand when you appear in court and the court addresses you as the defendant, they're basically saying you're here to accept the defendant's liability. So if you find it to where it's hard to get out of your court cases, if it's hard to get out of your foreclosures, if it's hard to get out of your criminal court cases, it's a presumption that you've accepted the charges. And that's why the court is being so hard against you. Okay, I hope you guys understand this because what I'm really just telling you is very simple. Without all of this words and all of this word salad, some of it is word salad, but I'm just telling you it is assumed if you allow the court case to continue that you are agreeing with the ruling of the court case. That's what is assumed. Now, a lawyer will come in here and tell you that what I'm saying is bullshit. He can't lie about the truth. It's a fact. It's called implied consent. So you may think, oh, somebody's forcing me to come to court. That's the psychological play of court. It's a play. That's why they're called actors. If you read certain cases, it'll refer to a judge, it'll refer to a prosecutor as actors. But if you don't read case law, I can't help you with that. Okay, so the presumption of government acting in two roles as executor and beneficiary, which they are for every traffic ticket. So what people do not understand about traffic tickets are traffic tickets. Basically, I have a video on that. I don't even need to expand on that anymore. I think I have a video on traffic tickets, talking about how, oh yeah, I think it's the man in blue is a friend to you. Everybody needs to go watch that video to keep it 100. That's one of my old videos. So, is that a matter at hand? The private bar guild appoint the judge, magistrate in capacity of executor while the prosecutor acts in the capacity of beneficiary of the trust for the current matter. Unless the presumption is openly challenged to demonstrate that you are both a general guardian and a general executor of the matter trust before the court, the presumption stands as you are by default the trustee. Therefore, you therefore must obey the rules of the executor, judge, magistrate. Now, you could just say basically, if you allow a judge to enter an order, or if you allow a judge to take over the matter, or you allow them to take over the matter, then you're liable. That's just how simple it is. You see what I'm saying? They try to put all this private bar guild, all this other stuff in it. If you allow them to take over the matter, if you allow them to rule on behalf of you, when you know that, like, if you have a foreclosure and you know the house is yours, you know that the judge does not have a right to do a disposition on your property by some alleged agreement that he doesn't even know is a valid agreement. These are the things that you have to know that. So, if a judge knows that you don't know that, they will enter a final judgment. And if you don't know how to challenge that final judgment, you're going to be on the side of the road looking crazy. But first is to, as soon as the judge rules in a negative manner, you have to challenge that ruling. Okay. The presumption of executor desan tort is a presumption that if the accused does seek to assert their right as the executor and beneficiary over their body, mind, and soul, they are acting as executor desan tort, or a false executor, challenging the rightful judge as executor. Therefore, the judge magistrate assumes the role of true executor. Now, what they're saying on an esoteric level, yes, this is correct. Okay, I'm not saying it's not correct, but yeah, what they're saying on a higher level, yeah, this is correct, and has the right to have you arrested. That's why he issues what was called a contempt order, detained, fined, forced in a psychiatric evaluation. Unless this presumption is openly challenged by not only asserting one's position as executor as well. So I'm not telling you to do all this stuff, saying that you're the executor or whatever. I'm just reading off this publication. Really just saying really what executor means is just taking over the case. You see what I'm saying? If you allow the judge and the prosecutor or the person that's suing you, because that's all the prosecutor is the person that's suing you. If you allow them to take over the case, then they're just going to make you the liable party. You see what I'm saying? So if you see that in court, that's what's happening. That's as simple as it is. If the person suing you in the court conspire against you and you allow it, then what you're doing is saying it's okay. Okay. Asserting everyone's position as executor, as well as questioning if the judge or magistrate is seeking to act as executor desan tort. This presumption stands. The judge is they're not going to answer that. They're not going to answer that. I guarantee you they're not going to answer that. The presumption stands, and the judge and magistrate of the private guild. See, this is where people who have property need to. I wouldn't do this on a criminal court case, but you can, you know what I'm saying? But I would handle a criminal court case completely different. But in a property case, you do need to ask, well, how does the judge have the right to do a disposition of property on a account that he's not even allowed? Like he has no right to transfer your property. So why does he feel that he has the authority to do it? I mean, the other party's not aggrieved. I haven't injured them. So how does the judge have the right to transfer or do a disposition of property? He doesn't. The presumption stands, and people say it's the contract. Yeah, it is the contract, but the contract is the only people who can argue the contract are the people who are party to it. So the presumption stands, and a judge or magistrate of the private bar guild may seek to assistance of bailiffs or sheriff to assert their false claim. That's why when you go into court, I had that happen to me where I went into court and that's the bailiffs were trying to punk me, and I was like, "No, I ain't going for it. I ain't going for it." And yeah, it made me have to spend a night in jail, but it was worth it. In my opinion, it was worth it because I stood for what I believed in, and I don't mind going to jail for what I believe in. Okay, the presumption of innocence, and I'm sorry, incompetence, is the presumption that you are at least ignorant of the law. Yep, that's why I try to teach people before you start trying to discharge debts, trying to stop paying your mortgage, etc. You need to learn the law first. So you need to know where everything could go. So then you already know how to deal with the pitfalls when it happens. It is virtually almost impossible to teach somebody the law in a month. It's almost impossible to teach somebody the law in a week. It takes months to learn the law. So therefore, incompetent and persistent, and present yourself and argue properly. So let me read that again. I kind of messed up, so got distracted. The presumption of incompetence is the presumption that you are at least ignorant of the law. And that's when you come into court and y'all wonder why you have a hard time in court, because the judge presumes that you're ignorant. That's why they don't listen to you. They know that somebody else is writing your stuff. They know that somebody else is feeding you a line. That's why you have a problem at court. That's exactly why, because the judge knows. Because when a judge knows a person that knows the law, they know they're not getting away with it. They know they're not getting away with it. They're getting away with it in the moment. But the person that knows the law, he knows how to react, or she knows how to react as soon as the judge abridges their rights. Okay, so as soon as the judge rules, that person knows what to do. So, like, if I'm in court, it's going to be different than you being in court, even if I'm coaching you, because I know what to do exactly when the judge abridges my rights. I already got it already ready for when I go in there. Okay, therefore, incompetent to present yourself and argue properly. Therefore, the judge slash magistrate as executor has the right to have you arrested, detained, fined, or forced into psychiatric evaluation, unless the presumption is openly challenged to the fact that you know your position as executor and beneficiary and actively rebuke and object to contrary presumptions. Then it stands by the time of pleading that you are incompetent. The judge or magistrate can do what they need to keep you obedient. And so this happened to me when I used to go into court and listen to people's stuff, take people's templates and paperwork and go into court and start up blah 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 blah, and didn't know what the hell I was. I didn't know the theory behind it. See, when you understand the theory behind something, it changes the dynamic, because most people walk into court, they can only see court on its face value. They can't see the inner workings of court. And when you can see the inner workings of court, it's kind of like being in the matrix, where you start seeing all those green codes, those numbers, and all that stuff. That's how the world becomes when you see everything, because you basically see it just like that, as coding and programming. The presumption of guilt is the presumption that, as it is presumed to be a private business meeting of the bar guild, you are guilty whatever you plead guilty. I'm sorry, whether you plead guilty, do not plead, or plead not guilty. Therefore, unless you have previously prepared an affidavit of truth and a motion to dismiss with an extreme prejudice onto the public record, or call a demurrer, then the presumption is you are guilty, and the private bar guild can hold you until the bond is prepared to guarantee the amount the guild wants to profit from you. This is 100% correct. 100% correct. If you want to know how to win court cases, this last paragraph told you everything. So, with that being said, I want to thank everybody on my road to 6,000 followers. Why not? Why not call it out and compel it? I'm going to start bringing more information. I'm going to start reading more publications, and I'll start going over them and breaking them down for you guys, so you can understand these at a high level. So you don't have to start out like me, where I was just, listening to people giving me stuff out of redemption manual and all this other stuff. And then I had to start doing my own research to find out a lot of that stuff is not correct. So you have to still understand the essence of what is going on. And with that being said, I'm out. Deuces.